Okay. Hello, 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 everyone. I'm going to give about 5 minutes for folks to start entering and navigating the technical difficulties that is Microsoft. So we will promptly begin at 6:05. Thank you so much, everybody, for joining. We're going to begin at 6:05 to give some time back to folks to be able to join us. All right, welcome everyone who has joined us. We are starting at 6:05. I feel like I should have some music in the background. Welcome, 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 everybody. Welcome, everybody. We are beginning in 1 minute. Thank you so much for joining us today. All right, all right, all right. So welcome, everyone. My name is Graviela Hernandez, but a lot of folks who know me call me Gabby, and I am the lead movement lawyer with SisterLove, and I'm excited to welcome you today. to the Know Your Rights, You Deserve Care Without Fear campaign's third episode of Pregnancy and Criminalization in Georgia. Today, we will focus on substance use, family policing, and of course, considering everything that we do, we are going to frame this PowerPoint and also this webinar through a reproductive justice lens. I am very excited to welcome our esteemed panelists who are coming together with me today with the understanding that everyone deserves dignity, autonomy, and support to make decisions about their bodies, their families, and their pregnancy. This webinar uses the reproductive justice framework to explore how systems of surveillance, punishment, and family policing in Georgia undermine these values. By learning how the child welfare system operates, understanding mandated reporting, and examining how discretion shapes outcomes, we hope that you can better protect yourselves and your families in our community, challenge harmful narratives, and advocate for policies that advance justice and equity for all families. So without further ado, let's get started. Okay, so on today's agenda, we are going to review national pregnancy criminalization trends and reproductive justice, the historical context of pregnancy criminalization and racial justice, and how pregnancy is policed in Georgia, and with a specific focus on substance use, mandated reporting, and defense strategies. So who am I? Who is SisterLove? Who is this speaking to you right now? So SisterLove is an organization founded by the trailblazer, the advocate, and one of the founding mothers of RJ as a movement, Dazon Dixon Jallo. SisterLove is the first women's HIV and sexual and reproductive justice organization in the Southeast. It was founded in 1989, so we've been operational for over 35 years to eradicate the adverse impact of HIV and sexual and reproductive justice challenges impacting Black women, women of color, and marginalized communities. The Justice Law and Policy Project, which is the legal advocacy program that I oversee, was established in 2025 in direct response to the escalating attacks on our civil rights, our reproductive health, and our bodily autonomy in today's political and social climate. The Justice Law and Policy Project is grounded in principles of movement lawyering and RJ, and we were created to meet this moment with courage, strategy, and vision. As the legal advocacy arm of SisterLove, JLPP is dedicated to advancing RJ, civil rights, and social equity through bold, community-centered legal action. We work through policy reform, public legal education, such as the Know Your Rights, You Deserve Care, such as the Know Your Rights, You Deserve Care Without Fear campaign, and grassroots organizing and cross-sector collaboration. So legal disclaimer before we begin, the information provided in this webinar is for educational and informational purposes only and does not constitute legal advice. Participation in this session, including asking questions or receiving general information from presenters, does not create an attorney-client relationship between you and any presenter, organization, or affiliated entity. Laws and regulations related to civil rights, reproductive health, and related issues are subject to change rapidly, especially in today's time. While every effort has been made to ensure the accuracy and timeliness of the information shared, we can't guarantee that all content reflects the most current legal landscapes. We will have a Q&A section towards the end, and for those who joined us in our previous webinar, we have extended this Q&A to be able to provide just a little bit of more time to ask questions. And then we hope that we maintain a space that encourages open, considerate discussion and mutual respect throughout the session. And so now I have the distinguished privilege to welcome Naran Elzarka, who is the Senior Helpline Counsel at Ifwin Howe Lawyering for Reproductive Justice. Welcome, Naran.
Hi, everyone. Thank you so much for joining us. I'm really glad that I get to be here with you all to speak about the importance of making sure that we talk about family policing and the criminalization of pregnancy when we discuss reproductive justice and when we want to fight for our communities to make sure that families can be safe. So I am an attorney at If When How, and I work on the helpline. So every day I am working and speaking with people nationally about access to reproductive care and navigating CPS cases, particularly ones that are not yet in court. So our goal is to create a future where every one of us has the power and support to make decisions about our bodies, families, and communities without barriers, coercion, punishment, and in safety and dignity. So again, just really trying to make sure that it is rooted in reproductive justice. The importance of family policing being part of the reproductive justice conversation is because in 1994, a collective of Black women activists formed Women of African Descent for Reproductive Justice and convened during a Black Women's Caucus. During this convening, it was really critical and recognized that mainstream reproductive rights movements, particularly the ones that focused on choice, failed to address the intersecting inequities that were happening in the lives of Black and Brown women nationally. So that is why the term reproductive justice was coined. It is rooted in social justice, human rights, and intersectionality, and it expands beyond just access to abortion or contraception, but really is about the core belief that people deserve to maintain personal bodily autonomy, have children, not have children, and parent the children that they have in safe and sustainable communities. And that is why we have to talk about the family policing system, because people cannot parent the children they have in safe and sustainable communities as long as the family policing system exists, as long as it continues to kidnap children, as long as it continues to criminalize people at hospitals or when they're seeking support. And we're here today to really like lay that out and think about all the different ways that we see this play out. So I am coming at this from a national lens. I'm really excited to hear Zoe and Emilie talk more specifically about Georgia. So I'm going to just spend a few minutes talking about nationally what it looks like for pregnancy to be criminalized in the family policing system. So what does child protection have to do with state violence anyway? It has everything to do with state violence. The child protection system is not about protecting children. It really is and has become about surveillance and coercion, and it's a reproductive injustice. So families should be able to choose if, when, and how they want to have children and raise their children free from state intervention. I'm sorry. We want to make sure that when we talk about the family policing system, we're recognizing that it is not a welfare system. It is just another form of policing, and it is rooted in investigations, surveillance, threats, accusations, shame, and blame. If it was about really providing support to families, then we would not see so much separation happen and only have, situations where families get worse when the family policing system intervenes. The reason I think that so much of the family policing system has continued on the way it has is because it's under the guise of child protection, but it's not. Families deserve support and not separation. So some examples of how the family policing system is a tool of coercion and control. So it surveils Black and Brown families. I know that when we think about the family policing system, we think about foster care. But the family policing system is more than that. It's about surveillance. It's about CPS making sure that parents know that they are watching, that they should be afraid to be around mandated reporters because they will just call the hotline and they will get in trouble. And this is a way that fear manifests itself in communities. There's always this idea that like someone is watching and someone is out to get you, and the family policing system has really weaponized that. I remember when I was a family public defender in New York, something that we would hear a lot is children recognizing how to use CPS against their families because they knew how powerful of a tool it was. So it really is not a tool of support. It really has become a tool of surveillance. And it's extremely coercive. if you don't comply with CPS, or if you're told, to do certain things and you push back, or you share your perspective on why you don't think that those treatment plans or case plans are right for you, you are then threatened with removal of your children from your care, or you're told that they will go to court and get a court order, or that they will, go to court and file a case against you, and that the judge will then have to decide what comes next. So it's extremely coercive, and it doesn't actually give parents a choice or the room to think about what they need or what they want. So much of these accusations are just rooted in poverty and inequity, and around, situations that parents find themselves in where support would be more helpful than policing. And that's what really brings us into the conversation around substance use. And it also breaks and tears families apart. This is a generational cycle. We have seen parents who were once children, where cases had their own parents filed cases against them, and they were the children that CPS was allegedly protecting. But what happened is that they did not get the support and love and resources that they need. And ultimately, when they got older and had their own children, CPS filed cases against them, because so much of that trauma was not addressed, so much of that inequity was not addressed. Instead of funding foster parents, we should be funding actual families and making sure that they stay close together, because that's how we provide support to families. And it also creates a foster care to prison pipeline. Again, what we see is children who enter the foster care system often have higher rates of suspension and expulsions, and juvenile delinquencies, which, we know there is a clear track to then the prison pipeline. So it's just a cycle of violence, and CPS is not always recognizing that that's what they are doing, that they are not providing support. And in fact, what they're doing is creating so much harm. And Emilie's going to spend some time talking about mandated reporting, specifically in hospital spaces, but the family policing system just simply cannot exist without mandated reporting. In some states, everyone is a mandated reporter. So it's this key element about surveilling people, monitoring people, making sure that they are aware that they can be in trouble at any point related to their family. So it is extremely violent in the way that we think about it. Next, please. So just to kind of hone in on substance use during pregnancy, but just very generally, like, a drug test is not a parenting test. It does not say anything about your ability to parent. It does not say anything about your ability to love or care for your children, but it is a key piece of the family policing system. Majority of the cases that come through the family policing system are related to substance use, specifically around pregnancy. And hospitals have become grounds for separation. Even well-meaning providers who want to provide support think that they are obligated to make calls to CPS despite having a lot of discretion, and often start the effects of separation and the idea that people are unable to ask for support because there is this fear that they will be criminalized and will get their children taken away. So even though many laws say that, a single positive test is not neglect, or drug use alone cannot be considered neglect, in practice, that's not what's happening. What we see happening is the moment a parent comes in and either shares that they are using drugs, or they are tested without their consent, or their baby is tested without their consent, and there's a positive drug screen, CPS is called. It is very, very rare when we see circumstances where CPS is not called. So again, what the law says and what actually happens are really different. And mandated reporters are often given discretion, but at the same time, mandated reporters are afraid sometimes of that liability, even though they are in places where they can provide support. So it's this whole system and this whole structure that's creating surveillance and fear for everyone involved, for the parents involved, for the providers involved. Everyone is afraid of getting in trouble. but what people don't realize is what they're doing is actually harming a parent and a child, and it can have really detrimental effects. Um, and this also brings up issues around informed consent and birth justice, and really, brings up why people may not feel safe going to hospitals to get the care that they need. Because when a hospital is a breathing ground for separation, and you're not going to get the support that you deserve and you are entitled to and you are requesting, people may not want to access that care. And it can also really impact maternal health outcomes and as well child outcomes. So it's important to recognize how detrimental this system really is and the long-term effects that it has. And then just very generally, we know that the studies show that the best approach for infant health and development is keeping a newborn baby with their mother or their parent. The parent-child dyad is extremely important, and that is fundamentally really destroyed when CPS gets involved in so many of these spaces. They can prevent a parent from being able to nurse if that is something that they want to do. It prevents a parent from being able to perform skin to skin and have meaningful visitation and contact with their baby. These are some of the most important elements of that mother-child or parent-child dyad in the early days, and the newborn days, and CPS is actively intervening and preventing that from happening, which can have really long-term effects on a family. Next slide, please. And then I just want to share this graph that shows that healthcare provider reports of infants to CPS have increased 400% in the last decade, but drug use has not increased 400%. And I want to give credit to Dr. Mishka Terplin, who has done so much incredible work and research around this. And what this really shows is that drug use isn't necessarily increasing, but reports to CPS are increasing and they have detrimental effects. So it just goes to show that more family policing involvement doesn't mean it's because more people are using drugs or more people are getting CPS or having CPS called on them. It's because the way that mandated reporting has expanded has just become so out of control, despite the data not being that people are using drugs more. Next slide, please. And then I also want to share what we on the Repro Legal Helpline can do for people who are experiencing CPS investigations. So on the helpline, we can provide early defense support. So if someone is dealing with a CPS investigation that is not yet in court, and trying to navigate what their rights are, so that can include, reviewing know your rights information, offering individualized risk assessments of the caller's different options. So we get a lot of calls from people asking if they should reach out to CPS, if they should call them back, if they should just agree to what they're telling them to do. So we'll kind of talk through some of these options and what it would look like to push back, what it would look like to, agree, and the kind of language that CPS is using, and just trying to prepare families when they are expected to meet with CPS or anticipated at a hospital, and really trying to identify resources or services that can help mitigate the risk of removal. So we are a national helpline, so anyone across the country can call us, but we have gotten numerous calls from, the past 2 years from folks in Georgia who are worried about CPS being called when they go to the hospital. We've also gotten calls from parents who are already involved with CPS asking them what their rights are and privacy rights are around like their treatment plan, what information CPS can get, how they can push back so that they can feel like they have a meaningful relationship with their therapist or their provider, and that they're not just going to turn over all that information to CPS. So really just talking through all of the ways that a parent can feel supported in getting the resources and care that they need to either prevent a removal or work towards reunification. And if someone is represented, we'd be happy to work alongside their attorney if they would want that. And if someone is not represented, we can also connect them with local early defense programs and attorneys to provide legal advice or possible representation if the case is filed against them. And at the end of the PowerPoint, we'll have all the information for the Repro Legal Helpline and how to get in touch with us. But I did just want to share now generally kind of how we navigate these cases. And we're here to support people in whatever way we can.
Hey everyone, my name is Zoe Bambara. My pronouns are she, her. I'm the Community and Volunteer Engagement Coordinator at ARC Southeast. We are an abortion fund, a regional abortion fund, and the most restricted abortion fund across the country. And thank you for joining us today. You really could have been at happy hour, you could have been asleep, but you're here. So thank you. So I'm going to talk about the history of family policing and how it's rooted in historic oppression, forced labor systems, racialized surveillance, all that stuff. And I will go to the next slide. So I want to start off by saying that a lot of this information I got from ARC. We had a decrim campaign last year where we had a series of conversations talking about how to destigmatize and decriminalize different topics. And I pulled a lot from our surveillance, the episode we did on surveillance. Also utilized a lot of information from the Upend movement, and that movement's to get rid of the child-like policing system. And also How to End Family Policing is a great book. I encourage everyone to get it. It's from Haymarket Books. So I want to talk about kind of the legacy of child policing, family policing. Of course, everything literally stems from slavery. Everything stems from slavery. So I wanted to start off by saying, then and now, Black families are precarious and they are disproportionately likely to be intervened upon by the family policing system. In 2020, Black children made up 25% of the youth in foster care, despite comprising only 15% of the national child population. Black parents are often forced to comply within dominant white systems. The family policing system requires parents to go through lengthy and convoluted processes to attempt to regain custody. And of course, this looks like and it mirrors when the book is called How to End Family Policing. And I'll drop it. Gabriella is going to send uh, a resource list at the end, and I'll make sure I'll add the book so y'all can have that. But so this, of course, mirrors slavery. While enslaved parents had to endure their bondage, strategically utilizing compliance and good behavior to avoid being sold and separated from their children. And of course, this is disproportionately Black parents that are involved with this system. So it all stems from, like I said, slavery. And then on this PowerPoint, it kind of shows, on this graphic, it shows the different parts of the family policing system, like personal responsibility, surveillance. And you'll see this in the next slide, but you'll see that Atlanta is the most surveilled city in the country. And like how people say Big Brother is always watching, not to sound like my dad, but Big Brother is always watching. So we have to be really careful with what we put, of course, on the internet, what we, our Ring cameras, everything is surveillance. Cops can use anything. The police can use anything. So yeah, I wanted to quickly, and I'll quickly read this paragraph. The U.S. legacy of a white ruling class removing children from low-income parents of color and separating marginalized families began with the practice of human chattel slavery, which reached what is now known as the United States in 1619. Viewed as property, enslaved Africans were not afforded the same rights to family unity as white enslaver. This reality, paired with racial demographics of the family policing system, presently indicate that both then and now, Black families experience the damage of child removal and family separation at disproportionate rates. And then, of course, we see this with the social construction of race and policing. During slavery in the United States, slave codes and patrols are reflected in modern day policing and prisons. And Naran really talked about how there is of course, like family policing system to prison pipeline. I also do a lot of jail and prison work. I speak to a lot of mothers who are currently incarcerated. And when I tell you, like, most of the moms that I see, they were in the foster care system, and now they have children that are currently in the foster care system. And most of the moms that I serve are Black. So it's a cycle. And then, of course, we also see this with the removal of Native American youth from the inception of Indian boarding schools in the 1880s and through their decline through the 1950s, which was not too long ago. I got an uncle that was born in the 50s. And so we see this. And then, of course, now we're seeing this after the peak of this after 9/11 for rapid and significant expansion of the surveillance state, the Patriot Act, the creation of Homeland Security, ICE, yada, yada, yada. And we can go to the next slide. So I kind of wanted to talk about what does surveillance look like, and mostly too communal like responsibility. I'm not a lawyer. I'm just little old boots to the ground organizer. But I think it's important for all of us to understand like our community responsibility and how we can protect one another. So talking about the different types of surveillance, you have physical police patrolling, and of course we see that in predominantly Black and brown neighborhoods, especially with all the, like the ICE raids and the traffic stops, X-rays and metal detectors, DNA profiling, the rise of AI, the data centers, all those things are we're going to get the brunt of it. Stop and frisk, clear bag requirements, digital, these are ring cameras, security cameras, GPS, traffic cameras, all these things the police are able to have access of. So it's just really important, to understand where and how. I don't want to keep saying Big Brother is watching, but Big Brother is watching. So child welfare as failing policing, of course, over 70% of children currently in foster care are there due to allegations of neglect. And I know Emilie's going to go into a little bit more about what that means and neglect, but I did want to say that it's really hard to prove what neglect is. And so when they're just trying to remove children from the home, they're going to put that because it's hard to prove. So the majority of the children in the US aren't separated from their parents because of abuse. They're separated for neglect, a code word that typically represents conditions of poverty, resulting in disproportionate separation and harm to Black families, which is especially shameful when you consider the cause. So when we think about the effects of slavery, Jim Crow, redlining, environmental racism, food deserts. I can go on and on and on about the different things that the state does to harm and to oppress Black and brown people, and then to take away their children because they're not giving the proper tools and resources to thrive. So like I said, it's a community responsibility as well for us to know our neighbors, to check in on our neighbors, and to be able to fill in those gaps that the state refuses to fill themselves. And then we kind of see the state use surveillance to criminalize pregnancy outcomes. We do see that. 79.4 of arrests took place in one of five of southern states. Over 90% of cases involved allegations of substance abuse during pregnancy, with 25% of those cases involving the use of legal and prescribed substances. And I love that Ron said that a drug test is not a parent test. Because yeah, you would think that's common sense, but like my dad says, common sense ain't all that common. And so I think it's extremely important to understand that we have to, when it comes to reproductive justice, we have to support it and fight for it from all fronts to protect children that are here, to protect pregnant people, regardless of their pregnancy outcomes. It's all connected. And yeah, I think that's really it on my end. I ended a little early, but I will pass it over to Emilie. I think I have one more slide actually. Yes. Okay. Really quick, really quick. It's just the criminalization of reproductive autonomy. So all these things, like I said, are connected. Racism, colonization, eugenics, ableism, capitalism, heteropatriarchy, the denial of reproductive care and autonomy, for incarcerated people, like all these things are connected. We have to make sure when we're fighting and defending for our reproductive rights that we're not forgetting the people who are always left in the margins. So yeah, that was my spiel, and now I'll pass it. Thank you.
Emilie, you are muted. Don't worry, it happens to everyone.
It's like the one thing you have to remember to do on this. Sorry, everyone. Thanks, Zoe. Your slides are great, is what I was saying. That was really good information. I love the way it was presented. Hi, everyone. My name is Emilie Cook. I am the senior staff attorney at the Barton Child Law and Policy Center, which is part of Emory Law. As I get into tonight's presentation, I want to note, like, it is after hours, and I want to be careful. I get really heated about a lot of these topics. I got angry making the slides the other night because there's just a lot to get fired up about. And so I will just note that some of these views that I'm expressing this evening are my own, and you know, trying to not get in trouble with the employer, particularly Emory as a hospital. Take note. But tonight I'm going to talk to you about how pregnancy is policed in Georgia. You've heard really good information about the system broadly, but I sort of think my task here this evening is to drill down into that and really bring this home and explain, you know, how this is manifesting here in Georgia and what your rights are. If you begin to encounter the system or have friends or family members who do, I am going to try to give you information, because knowledge is power, particularly in this context, and we are woefully under-resourced when it comes to meaningful legal representation in investigations. So with that, we will kick things off. Next slide. All right, so when we are, I think this has already been framed out pretty well, but right, when we are talking about pregnancy and substance use, it is not just medical, right? It should be, but it is not. It is highly surveilled. And this is really at that intersection where healthcare and family policing, like, most clearly, right, come together and intersect. Too often, substance use during pregnancy does become a child welfare issue. I want to note too, I don't typically like to even refer to it as the child welfare system, right? And generally use family policing, but because this is the know your rights piece, I'm going to use the language that is reflected in our statutes and under our law, because it's important that I want you to be familiar with that language. So many families are first encountering CPS right at the hospital at birth. I'm going to explain why and how that's justified. And certainly, as has been pointed out, medical providers are that primary entry point, one of the primary entry points into the child welfare system in Georgia, both for during pregnancy and reports when people take their children to the hospital for care and treatment. I don't think we're not getting into that tonight, but that is definitely a big part of the picture as well when it comes to medical providers. Next. Okay, so I'm going to throw out acronyms, and the law is filled with them, particularly in the child welfare space. When you hear me talking about DFACS, right, I'm talking about the Department of Family and Children's Services, which is Georgia's child welfare agency. You'll hear me talk about CPS, so that's Child Protective Services. It is part and parcel of DFACS. It is just sort of the investigative unit, the investigative wing of the department. And when I am talking about reports, right, I'm talking about those calls to our centralized, it can actually be calls for medical providers, it can be emails and other forms of contact. They have a few options in how to reach out, but it's the process where someone is making a contact with centralized intake to alert CPS of a suspected case of child abuse or neglect. As you have heard, that neglect, right, is a very broad umbrella. It is essentially a conflation of issues of poverty, are too often alleged to be neglect. But actually, for tonight, and when we're talking about the issue of substance use, that is falling squarely under child abuse because of the way our statutes are designed. And so those from the outset, substance use calls are related to allegations of the abuse piece of child abuse or neglect. Next. All right, I want to give you a little bit of context for like how big this issue is that we are discussing, right? So I pulled some data in preparation for tonight. The most recent data that's available, which actually just came out within the last couple of weeks, but I can report that in fiscal year 2025, so that's going to run from October of 2024. When I'm talking about years here, it's federal fiscal years, so like October of 2024 to September of 2020, end of September of 2025. In that time, Georgia CPS received 114,500 reports of suspected abuse and neglect. I don't know if that is shocking to anyone, but that is a very large number, right, of reports that are coming in. Of those calls to CPS, 73,000 resulted in direct interaction with Child Protective Services. What I mean when I say direct interaction is like face-to-face contact, report, and even if face-to-face contact wasn't successfully made, they showed up and attempted to have a contact with a parent or the person alleged to have been the perpetrator under the allegation. So 73,000, again, a huge number. We actually are a little unique. Nationally, medical personnel tend to be like the third largest group of reports to Child Protective Services, but here in our state, they're actually the second largest source. So they are number 2, right behind childcare and education personnel, schools, right? Schools and daycares are the other the other top reporting source. When we look at the outcomes for those reports, medical reports from medical personnel tend to be substantiated, and substantiated, unsubstantiated, it means they find that like there is merit to the claim, okay? They tend, and that it's going to be pursued further and go deeper into investigations. So reports from medical personnel are substantiated at a higher rate than all the other reporting categories except for law enforcement. So medical personnel, huge driver of child welfare system involvement in Georgia, right? That's why I opened with that. In fiscal year 2024, this is the most recent. I can't tell you, this comes from federal, what's called federal NCANS data. And it is only released, it is 2 years behind. It's the cycle of release 2 years behind. So the latest data we have on that was that Georgia CPS in 2024 received 2,570 reports specifically for infants that were born due to substance exposure. Next slide. Okay, you've heard some references to mandated reporting, and I kind of gave you the context of what reporting generally is. But when we're talking about mandated reporters, our law outlines child care professionals or some social workers, can be therapists. It really depends, right? We have certain categories of professionals who are required under law to report suspected, huge, like that's a red flag in and of itself, right? Because what does suspected mean? But they are required to report suspected abuse and neglect. So for our discussion tonight, doctors, nurses, hospital social workers, anyone at a medical, at a hospital or a medical provider is essentially going to be covered under that. Now here's the key. So drug testing is often the thing that kicks off that report, right? We'll get into that, but it's often the reason why the report is it's what gives rise to that report in the first place. Drug testing of mother and or infant at birth is not required in Georgia. There is nothing that says that they must run those tests. However, federal and state law says that if a positive test of a newborn, right, occurs, then it must be reported by our mandated reporters, those doctors and other professionals, if here are the actual conditions for when that report must be made, okay, is if you find symptoms of withdrawal in the newborn, or, and this is the one that is driving these unnecessary and highly surveillance-oriented calls, or the presence of a controlled substance or a metabolite in the newborn's body, blood, urine, or meconium that is not the result of medical treatment, okay? And I want to focus, like, that's really the main primary driver here. So that is the definition of prenatal abuse, which we're looking at right there. Part A and Part B is part of the definition of prenatal abuse in the state of Georgia. Note that all it takes is the presence of a controlled substance, right, or a metabolite in the newborn's body, blood, urine, or meconium that is not the result of medical treatment. Now that's the key. The problem here is that many healthcare providers, I mean, that statute as it stands is problematic in that it's casting this massively wide net, but many, many medical providers do not understand when they're actually required to report. And far too many medical providers tend to report every single time a controlled substance, right, is indicated in the newborn's body, blood, or urine or meconium, irrespective of whether or not it was the result of medical treatment. They're making the call anyway. And unlike other types of allegations in the state of Georgia, if I am concerned about my neighbor and I'm, going to file a report because I think that they're not feeding the children or something, and I call and I make that report, for most reports that come in, remember we talked about 73,000, right, of those 114,000 calls, many are screened out, meaning they find that the call is looking for like maybe some help or some services, but it's not really an abuse case. So it just gets screened out. Here's the problem. There is no opportunity to actually screen out calls from medical providers about substance use appearing in the system. What I mean by that, they call it under, this is going to get dense for a second, but follow me here. They refer in the Child Welfare Policy Manual to these types of cases where it was medically prescribed. Okay, so mom tests positive for, or the baby's blood tests positive for some sort of painkiller that was actually utilized in the birthing process. That reporter is someone who misunderstands. Let's say that physician is someone who misunderstands their requirements to report. And so because the baby tested positive, they're filing a report anyway. And maybe they're thinking, it's not really my problem to like sort out, the state will figure out what to do with that call. While it is considered not a maltreatment call, and the state identifies it as a non-maltreatment call, it still is going to trigger further interaction. So we'll get into that on another slide, but why that distinction exists, it used to matter when we had a child abuse registry where reports that were substantiated versus unsubstantiated were either included on the registry or weren't. In Georgia, we are the only state that no longer has a child abuse registry. That is not because we are progressive and so advanced and thought we would get rid of this horrible thing, which registries are. It's because they mucked up the legislation on it so badly that it was struck down by the Supreme Court, and they just have not gotten back around to fixing it. And so they've left it alone. So we have no registry. But that maltreatment versus not maltreatment, registry versus not issue, has created very murky waters within this statute in particular because of the way the calls come in. I know that was a lot. Sorry. Next slide. So the key takeaways, I want to, again, setting the stage here, the hospitals are not required to administer the tests, right? But if the baby's test is positive for a controlled substance, then they're only required to report it if they suspect that it was an unlawful, right, use, like the substance test to be unlawful, and they don't believe that it was prescribed, or the medical charts don't show that it was administered during the birthing process, or mom doesn't have a history of being prescribed that substance. That's the only time they have to do it, but that is not the only time that reports are generally made. It is routine in many circumstances to report those screens no matter what. And that's because they're just not clear on their obligations, or because I don't know why. Honestly, we will have to get some medical providers together for a panel to have a better conversation about why they keep doing it anyway. Next slide. All right, so what happens next? Here's where we're getting into the meat of it. If the medical personnel makes a report to CPS based on that positive screen, or moms, right, there's no requirement that they ever report because the mom tested positive, but that doesn't mean that they won't, okay? But if they make the report based on the baby's positive screen, Then central intake is going to call that medical provider to collect additional information. Now, here's the thing. You would think that during that call to the medical provider to collect additional information, they would collect information like, and they do, but like, was this drug administered as part of the birthing process, or does mom have a valid prescription? And they do get that information, and they do note it in the record. But nevertheless, no matter whether it was prescribed or not, it's going to trigger mandatory face-to-face initial, it's called an initial safety assessment, that has to be conducted within 5 weekdays of the initial report, which means they need to make they're going to require a caseworker to come out and make face-to-face initial contact within 5 days of the initial report, even if that call is related to something that was administered during the birthing process. That is infuriating, right? That is surveillance to the max. There is no excuse for why we continue to allow that to happen in this state. But alas, here we are. Also note that 5 weekdays, right? You've just given birth. And so within 5 weekdays, you will have a CPS. Technically, it's not the CPS unit, but anyway, you will have a caseworker face-to-face in front of you asking questions. And we'll talk more about what that assessment looks like. Next slide. All right, so what does that safety assessment look like? I pulled the DFACS policy. Again, I feel like knowledge is power, and understanding what's going to happen next can be really important in protecting yourself. Here's what the policy actually says that the caseworkers must do during that initial safety assessment. They're supposed to assess, right, health, developmental, and substance use disorder needs of the mother and child. Mind you, right off the bat, this drives me nuts because, again, that safety assessment is required regardless of whether or not the medication was prescribed or part of the birthing process. And yet, the first line of the policy is that they are to come and assess substance use disorder needs, right? So we're making a presumption here, I think, about something that exists with absolutely no evidence, and it colors, I think, everything that happens next. They're then required to coordinate with the family and the hospital and others to plan for discharge if you're not already like home with your infant. Determine whether the medication was prescribed and verify, right, medically assisted treatment status if that's applicable. Again, the fact that they're there to verify Matt is infuriating, right? You have a right to use this, to use medically assisted treatment, and the fact that the state comes to check up on that is infuriating. They are there to assess and discuss safe sleep practices and take action to remedy those any unsafe sleeping. They also will make a required referral to the Babies Can't Wait program, which is the program that serves 0 to 3 and provides in-home, often, services for mother and baby, plus educational materials. I'll note that there can be repercussions if there's a Babies Can't Wait referral and then, you don't participate with that program because you're not really interested, then no thank you in having additional services. That can cause problems for you, but the Babies Can't Wait referral is made. They then, under federal law and state law, are required to develop and implement a plan of safe care. I'm going to talk about a lot of different plans that involve safety you'll see in this presentation. I break those down on another slide, but this one is called the Plan of Safe Care, and they're going to supposed to coordinate with your medical providers and others. This process of accomplishing these things, right, 1 through 6, they're going to inform the parent that that process will take about 45 days. So in that time, DFACS will be contacting mom's medical providers to assess compliance with any treatment plans or medications or health-related needs. And then other agencies after 45 days, any other agencies you're involved with, Babies Can't Wait, these other groups, right, are supposed to continue to monitor the family and any referred services after DFACS closes its case. And again, all of this is triggered very often by a report that was never required in the first place, that a provider decided to make either as a routine practice or because they misunderstand the law, or because they're incredibly biased and racist and just do it anyway. Next slide. All right, so that gets us past what's going to happen no matter whether that substance should have been there or not, right? As far as in the blood and in the meconium. If the substance was not lawfully prescribed or was illicit, anything THC, right, methamphetamine, any substance that's a controlled substance under Georgia law. I forgot to mention one of the earlier slides gave you the code section where you can read that full, it's 5 statutes that covers, right, our scheduling of controlled substances, big long lists. But if the substance was not lawfully prescribed or they think that it was taken not as prescribed, then they will also launch into the rest of a full investigation, which is to assess whether the parent, guardian, or legal custodians or any other adult members in the house have substance use or alcohol issues that impact family functioning, which they will continue to monitor throughout the life of the DFAC's involvement, which remember is minimally 45 days, and you are notified of that and sign something acknowledging that. They will talk to and drug screen all parents and guardians and legal custodians in the household. If the use is alleged, suspected, or confirmed to impact family functioning. The WHO makes that call about whether it's alleged or suspected or confirmed to quote unquote impact family functioning. It can be it could be the medical providers, it could be the caseworker themselves, it could be another family member who's interviewed. It could be your Facebook posts, right? They might get on and look back at history and decide that they can see where you were referring to having done drugs or taking pictures out and maybe, during the school day or who knows what, okay? But it can be alleged, suspected, or confirmed to impact family functioning. They will continue screening all parties to monitor substance use. So if those first screens they do on the individuals in the home turn out to be positive, now they're going to continue doing regular drug screens throughout that period. And it's probably going to escalate much faster if they both have concerns about family functioning, right, impact on family functioning, and end up with positive screens, not even necessarily mom, but any other adult in that home or caregiver or someone they think will be around the baby. They're going to continue to monitor. They will run a substance use disorder assessment, which means they'll put in a service referral to another provider who specializes in these substance use assessments. And I'll just note, also tends to administer substance use treatment. And it's interesting because if you ask people who provide substance use treatment whether someone needs substance use treatment, you very often get an affirmative answer on that, right? They very often say, yes, this person's in need of level 2 services and good news, we provide them. So that's deeply problematic. They will also engage what they call collateral contacts, meaning other people in your life that they encounter or that you point them to or that another family member brings up to assess impacts of use on protective capacities and child safety. If that substance use assessment does recommend that you participate in anything from, NA classes, rarely does anyone have a positive drug screen and then a substance use assessment that doesn't recommend further stuff, right? So whatever that substance use assessment recommends, then they're going to monitor to make sure that you're compliant and participating in that. And all of this is still, remember, we're still in investigation. We haven't even gotten to the point of contesting anything, right? We're not in court, none of that. This is conversations happening behind closed doors. Next slide. Okay, so possible outcomes. I noted that, right, there was the plan of safe care and then there was this and all these other things. This is just to give you a breakdown. We've gone through these, but right, so even if it's prescribed and appropriately taken, you have to have that minimum 5-day meeting and the plan of safe care, and DFACs will hang around and ask for things and check on things for about 45 days, and then they'll generally end their contact They're not calling it an investigation if it's prescribed use. That's just part of the initial safety assessment, not an investigation, just for safety. And then they'll generally end that contact after 45 days. They may or may not tell you anything. They may not wave goodbye on the way out the door, but that's generally about the time frame that it ends. And again, that's assuming that there weren't positive screens afterwards and there weren't recommendations from a substance use assessment and all of those things, right? That's like full compliance, best case. They wave goodbye and they're out. If it was illicit and not lawfully prescribed or not appropriately taken, then again, you've got that functional family assessment. If they go through that period and decide that there's no safety threat here, then they may close the investigation, or they might refer it to what they call family support services for what's like an alternate response, which is additional services and more time monitoring. That's really what it does. Is it at 45 days, they're kind of required under law to like do something, right? And make a decision. So sometimes that will become a family support services case. If they did identify a safety threat, so if in all of that time they've come up with something that they can actually pinpoint and say, this is a viable safety threat, this is a serious safety threat, then they'll talk about doing a safety plan, or they may go seek a court order for removal or file a petition in court. Either way, so it's sort of a safety plan, which is let's keep working together. No need to involve the courts or the law or the attorneys or any kind of defense. Let's just agree to a plan ourselves, or they'll take it into court. Next slide. So there's some critical distinctions, right? That plan of safe care, that's the federal one that's supposed to be focused on medical need. The initial safety assessment is that one that is responded to within, or the assessment that is kicked off with that 5-day response period that is required for every report for substance use positive, or a substance positive in terms of the baby's blood or meconium. And then the safety plan is what we're going to get into. The safety plan is this: we're not taking you to court. We're not going to try to remove the child as long as you do these things. And that's what I'm going to talk about more now. So those are very much conditions and restrictions on contact. Next slide. As I'm talking about all of these things, I hope that it's really becoming apparent that discretion, like this is a system just rife with discretionary decisions. So discretion determines which mothers and babies are tested, which instances of positive screens end up being reported, which families face further involvement, what kind of restrictions they face once they, are dealing with the system, and then which investigations become court cases. So we have a system rife with discretion. And in the state of Georgia, last data I could pull, we have 171 hospitals, right? As many of you know, we have 159 counties, and those are broken up into 14 DFACS regional offices. When you have a system that is layered on surveillance and then discretionary decisions across all of these different hospitals and counties and regions, you end up with a system that has totally different, right, outcomes for different families. And bias is influencing those decisions, right? Implicit bias, explicit bias. We all, right, are impacted by our biases, and particularly in a discretionary setting. Next slide. Okay, so defense strategies. I'm going to talk a little bit about what you can do in light of, the deck is very much stacked against families, right? So what do we do with that? How are we supposed to handle that? And I want to, before I get into this, I want to say, I really want to be able to sit here and say, they come to the hospital and you say, screw you, right? You say, I don't want to talk to you, leave. I have no obligation to do so under the law. You'll hear me. That is an approach, okay? The reality, though, is that it can carry really great risk. And so while it is absolutely well within your rights to do it, and you should use that and you should assert your rights and advocate for yourself, it is important to be prepared for what may happen next, right? So there's some things we can do, regardless of whether we're going to assert our rights, to prepare for worst case, and that can be really important. So engaging with trusted support services before the baby is born and staying connected. So I'm talking about if somebody is dealing with substance use issues, finding providers that they do like, finding good peer mentors and support groups that they do like, and staying connected with those groups can be really, really important, not just because we all do better with support, but because it is later you can use that as evidence that there is not a safety risk here, right? I am doing what I need to do to take care of myself, and I'm perfectly capable of doing what I need to do to take care of my child. Also seeking medical documentation for any kind of substances that are used during pregnancy. And again, that is an attempt to be proactive, both for your own your own care and well-being, and to prepare for worst case scenarios later in terms of evidence. You have the right to talk to your medical team, right, about drug testing policies, and you could consider speaking with like the hospital's patient advocate. I'm not necessarily about use and making disclosures, because right, we've learned that all of those individuals are mandated reporters, but speaking to those providers about their policies around these things can be really important. And I know that's really hard to do when you're in the middle of like rape birth and thinking about all these things. It can be really overwhelming, but have somebody else ask, right? I have advised clients to like, well, while you're there, because they didn't know how to approach it without seeming like it was seeming like they were disclosing or raising a red flag. And so I said, you know, have your mom ask like as an offhand thing, right? Like, oh, I was watching something the other day. What is your policy on XYZ? Sometimes we have to get creative, but it's just the reality. You can document all prescriptions. So just make sure that if somebody prescribes you something, you know, while you're pregnant, that you are keeping that prescription, and that you have documentation, you have access to it, and the ability to pull it back up as needed. Speaking with trusted friends and family members about serving as a safety plan support person. So with this, I'm talking about someone who has, doula, absolutely. When I should have mentioned that when I said like engage with trusted support services too, your medical care team, right? You have the right to pick your medical care team. If you can connect with a doula, like so instrumental in these processes. Speaking with friends or family members, what I advise clients, if we know, like if they're using medically assisted treatment, right? If they've got MAT for substance use, and I know that there's a very high risk that is likely to be reported on a CPS, then what we do is try to identify family members and go ahead and have that conversation. I am going to do everything I can to defend that individual during the investigation and push back and fight. But it is a big help to have already like have our ducks in a row, because the worst case that we're preventing against is that we don't want a court case. I want to be really clear and prepared and ready and say, we don't need your services, right? There's a plan in place. The baby's going to be, grandmother's going to be in the home or whatever else. Have a plan in place, right? If there is a substance use issue, have a plan in place for treatment and support following birth. This one, it makes my skin crawl that I'm even having to give these, because again, I just want to be able to scream from the rooftop that screw you and get out of here. But it can be helpful to prepare your home if you know that you're very likely to face a report, to prepare your home ahead of birth in case of like a home evaluation, because that is right within that 5-day report window. They may be coming to the house. And while I can raise and yell at the caseworker all day about how noting that there were a pile of dirty dishes in the sink when mom just gave birth 3 days ago is absolutely absurd and they should be ashamed of themselves, it doesn't change the fact, right, that it still gets recorded and the deck is just so stacked against us. Next slide. So if you do have CPS or DFACS case history that does place parents at a heightened risk, so I just want to highlight that you are not required to cooperate with an investigation. And I often encourage people, do not require with an investigation, particularly, right, if you've taken some steps to prepare and like we're going to be on good footing and we know that we are like ready and prepared to assert our rights and stand our ground, then absolutely that is an option. I think I am getting really close on time and we were going to leave time for questions. Gabby, do you want me to speed through these left? I don't even know how many I have left on there.
No problem. I think if we stop at 7:15, that'll give 15 full minutes for questions. So you're
Okay.
good for another 6 minutes.
Okay. All right. I think we'll get through it. Made these little dents, guys. Sorry. Okay. So, documentation. Document every contact, every conversation. And again, these are the tips when you're interacting with CPS, right? If they show up at the hospital, document absolutely every conversation that's had. And it can be really, really helpful to talk to a friend or family member to be like your note taker, because if you've just given birth, the very last, you are not in a headspace to deal with the stress and fear and the contact and all of that comes along with this, which is why it is profoundly unjust, right, that they're showing up in this space in the first place. But they do, and being able to recall what it is they're saying is vitally important. And parents are usually not in a good space to be able to do that. So enlist a helper in that regard can be really helpful. Your doula, in some instances, are there and have stayed by my client's side to have that conversation. Side note, you do have the right to record conversations. In the past, I've often had clients that are like, I have all of this stuff recorded on my phone. That's good, but that note taker person is even better, because it's just a thing about court records, having that written documentation that was taken at the time. It goes into evidentiary things. Often juvenile court judges are not interested in sitting there and listening to recordings that we try to present. So that's why I say that. Next slide. All right, safety plans. You know, I said that if not every time that you have this 5-day interaction is going to result in a safety plan. But if the conversation starts turning towards this issue of safety plans, there's a few things that I would advise that you ask. And again, that note taker, that you get really specific on this stuff, right? But key is, what is the specific safety threat that's been identified? Because that is the justification for going into this next step process of safety plans. Asking for additional time. You have the right to say, hey, look, I'm willing, whatever is going on here, fine, we can talk about it, but I would like an opportunity to better understand my rights and to speak to legal counsel or to take a beat. It is my understanding that this is a voluntary process. You can say that, right? It often asserting that you understand this process and that you are familiar with, right, the policy and you know what's going on, can begin to shift some power back, right, in the dynamic, because it is a highly coercive process. And so it's important that we express what we know. If you, just so you know, if you don't agree to a safety plan when the department gives it to you, DFACS would have to seek a court order, which means they'd have to present evidence in court. And things like THC only, that's going to be low risk for the court's threshold, unlikely that they would go to court. But if it's and if it's a prescribed medication, low risk. But if we get into other illicit substances, the risk mounts, right? As far as whether this would end up in court if the safety plan is not agreed to. I would also love to be able to say that that's fine. Let's get them into court and they won't be able to meet their evidentiary burden. And that is often true in like Fulton County and DeKalb and some of these other, some of the bigger juvenile courts that have more robust defense teams and just better practices in their courtroom. In the rest of the state, I live in Baldwin County. If you are in rural Georgia, it's just extremely hard to defeat the filing, because sort of what the agency says goes. And yes, we can appeal it, right? I have appeals pending. We can appeal it, but it may take a year and a half for that appeal to work through the system. on a bad dependency finding. So again, the deck is profoundly stacked against families. Violations can be used to justify removal if it comes to that. The thing that I would want people to be aware of, if they're looking at that safety plan, every one of those terms, it should not be things like mom or dad will demonstrate that the child is safe in the home. That is not a real objective. How do you know when that has occurred, right? What's the yes or no on that? Something much more fitting would be like, will complete a substance use assessment and follow recommendations. I don't like that as a term, but at least it's concrete, right? And we know what the task is, and we can say it has occurred or hasn't occurred. Next slide. And was that note for me to stop at 7:13? I saw a comment.
Yes.
Okay. If people are gonna have access to the slides, I can just kind of stop there. There's some other, I mean, the information is dense, but I did try to pack it all in so that it's there if they have access to the slide deck after.
That sounds great. Yeah, we can send out the slides right after the webinar.
Okay, I'm sorry that I tried
No,
to pack too much
please.
in there, guys.
This is amazing. Thank you so much. I'm just gonna go ahead and move us away. Yeah, this was absolutely phenomenal. Echoing everybody in the chat. Thank you so much, Emilie, for your hard work on this. I'm gonna go ahead and move us through to the resources and invite Naran to come forward and speak. Naran, there's about maybe a minute or two to go through these resources. So just want to uplift that.
Sure. Hey, everyone. So I just shared some resources here that we'll share out in the slides so you can click through them. But the Mandatory Reporting is Not Neutral is a really great resource. They have a ton of videos and trainings on mandated reporting, discretion, ways that providers can do less harm, ways that providers can think about their pods and resources around them to support people. And this can be really great also for community members who might, also be doulas or birth workers or providing support to people who are using drugs and might be at risk of CPS intervention. And then the Movement for Family Power movement map also includes just different resources across the country around organizing, legal resources, and mutual aid for various legal issues around family policing that people might be experiencing. And then I also, next slide, please. We also have a Doing Right at Birth video course. So if folks want to learn more about the role and the ways that, you can support people who are using drugs and thinking about just different ways that we talk about birthing people who use drugs and how to provide support in different ways and strategies for also interrupting that harm. Next slide. And then this is the number for the Repro Legal Helpline. So we can answer questions related to abortion, pregnancy loss, birth, and that also includes early defense or CPS investigations that are not in court that are related to pregnancy or drug use during pregnancy. Next slide, please. And then the Repro Legal Defense Fund is also a really great resource that provides funding for bail and strong defenses for people who are facing criminalization because of pregnancy loss. And then lastly, next slide, if you want to get involved, we are always looking for people to join our network. You can join lawyers and advocates across the country, figure out different ways to provide support to people who need it. And you do not have to be a lawyer to join. So we are always really grateful for anybody skill set, resources, network connections that they have, and ways that we can just support our callers nationally. So I will hand it back to you, Gabby. Oh, you're muted, Gabby.
Oh man. Okay. Thank you so much. Thank you so much to our speakers today. Thank you so much for attendees who have carved out time out of their busy schedules to be here with us today. We learned a lot. We went through the national landscape. We learned trends. We learned how this connects to a broader historical context of slavery, as well as racialized oppression. And then we went into the nitty gritty with respect to discretion and the laws around mandated reporting. So I want to go ahead and open up the Q&A to any questions that you may have, and then we can go ahead and direct them to the correct speaker. So I'm going to pause and give a few minutes for y'all to formulate some questions. And if none come through, we can go ahead and close out, but we do want to leave some time just because last webinar we did kind of run over just because it can be very dense and a lot of information. So I'm going to pause.
I do see one in the Q&A chat.
Wonderful. Okay. Let me navigate. Let's see. All right. So my sister is an L&D nurse in Warner Robins, and she told me that they automatically test every laboring person and baby for substances. Can birthing people explicitly decline toxicology tests on their blood work? Emilie or Naran? Mhm.
Yeah, so mothers, right, can absolutely decline if you if the opportunity is there. The problem is it's you right like this, like you don't know what's happening, so you're not necessarily informed that, hey, we're about to do this, are you okay with it? It should be that way. You should have to give informed consent, but that's not always the case. You cannot decline there's nothing in our laws that would give a mom the right to refuse and have that refusal for the baby to be tested be honored by the hospital. So that's a medical decision to provide for the care of the child is generally the way that's treated.
And I would also add that if someone did choose to decline, like they have the right to do that, but there can be some legal risk around it. So I would just be prepared to know what you're going to say if they ask why, or just have like a game plan or some support to figure out what your next steps would be. But you absolutely can decline for yourself. It just doesn't mean that it'll go away, or they won't bring it up again, or they won't still make the call and say that they suspect it and that you're failing to cooperate. That is something we have seen as well.
I have a question as a birth worker in doula. I'm wondering, because birth can be chaotic, depending on what's going on. So I'm wondering, would it be, I guess, useful, and does it hold any weight to put, if they want to decline it, put it in their birthing plan?
It wouldn't necessarily, I think it would depend on the staff and the nurses and the doctors that are working with the parent.
Okay.
But I also think like it may not necessarily prevent like a call from being made. I think if they are asking for some sort of test being done or some sort of intervention and they are not getting their way, I don't think that the birth plan would prevent that from occurring. But I do think clear communication in advance could be really helpful. So a parent could ask, like, I would like to know what I'm being tested for before you test me, and just, navigating that, whether or not it'll prevent anything. But I think if a parent knows in advance or asks, like, what can I expect at my next appointment, they can also make different choices around their usage levels. If they try to not use for a bit, I think it can just provide people a little bit more information to figure out what the plan could be. And I think also a doula can provide some advocacy just around informed consent as well, and kind of create that buffer between a patient and a doctor or nursing staff or a hospital social worker. But I don't think that the problem would just entirely go away either.
Okay, that makes sense. Thank you.
I don't think it resolves the problem. I do like the idea of the documentation though, right? Where it's like, oh, we made the report because mom refused the drug screen, and then the caseworker is saying, well, there was a refusal. I would like to feel it would be great to be able to look back and say, hang on, you're painting this like mom specifically refused a drug screen because she's got a substance use issue. This was outlined in her birth plan along with this laundry list of preferences about the experience she wanted to have in the hospital, and it didn't include being drug tested.
Absolutely. Yeah.
That's like that is helpful, I think. But yeah, it doesn't unfortunately stop the thing from happening.
Thank y'all.
All right, we'll give a few more questions for questions to come in, or a few more minutes for questions to come in. I do have a question related to discretion, and how do we, on a policy side, how would we implement policies that can kind of close that gap or narrow how broad the reach of discretion truly is? Would it be these sort of compliance programs and implicit bias trainings that a lot of folks within the RJ community are pushing for at the state legislature? And what are your thoughts on making sure that we're regulating this family policing system in a way that serves our community at the Capitol and in our local governments?
I think maybe it just generally like providers should really know what it means when they make a call. That when I think a lot of providers sometimes think they'll just say, oh, if nothing is happening, like then everything will be all good. But at least like I made sure to, clear my conscience. I think being really clear with providers, like what it looks like. So maybe policies around education around like the life of a case or what an investigation can look like, the way that it's harmful, even if there's no removal. Um, and also, I I don't know, wishful thinking, but like just actual general policies that reduce and remove stigma around people who choose to use drugs and actually thinking about ways to provide support. And that if a parent is, you know, reaching out and asking for support, like they are capable of caring for their children, and a provider cannot be the one to like make that determination.
I think we should strike the prenatal substance use statute altogether, throw it out, get rid of the definition. We have no shortage of opportunity to find neglect and abuse in cases that don't involve prenatal substance use, right? They can make a case if they're going to do it based on actual like the safety criteria that they already outlined for every other report for child abuse and neglect. We don't need a special specific thing that says if a substance is found and it wasn't prescribed or it was illegal, it was, THC in the system or it was whatever, that automatically constitutes prenatal substance use. It's wildly unnecessary. I mean, I accept federal law. It's part because of CAPTA, right? And the other requirements. Nevertheless, like we need to be targeting those laws. Like that law sets up a system that is designed to result in this like worst case interaction immediately after giving birth. I didn't even get into like it cannot impact, like you're right, they'll tell you can't breastfeed. There's so many things that fall out because of that.
And I am putting the Birthing Bill of Rights in the chat right now. And I'll give a few more minutes for questions as well.
I see a question in the chat about asking if anyone has created a birthing person's Bill of Rights or KYR type of document specific. So I'm just wondering, I think from the resources that Gabby's going to share, like there are a lot of Know Your Rights resources in there as well.
I don't know that we have any, I'll say like that's a gap. Like I don't know that we have any specific to like this idea of like CPS investigations in this context. It'd be a great, it would be a great resource. I can see if we can pull that together through Barton.
I also want to highlight that in our first webinar, specifically focused on advanced directives in the case of Adriana Smith, who was the woman in Georgia who was kept on life support without and irrespective of her family's wishes, we created somewhat of a comprehensive webinar where we brought forward doulas, legal professionals, as well as folks working within leadership at organizations for Black mamas. And with that being said, I'm going to put in the chat the webinar link, because one of the doulas wonderfully went through about, I want to say 20 to 30 minutes, specifically focused on how to create a birthing plan that honors your rights. And then we had another doula that works on the Birth Justice Care Fund of Sister Songs specifically. For those that might not know what the Birth Justice Care Fund is, they provide like resources for pregnant people who are navigating the perinatal health period. And so she also went through the patient Bill of Rights and how it's important to go through the hospital if that's where you want to birth, if you want to birth in the hospital, to specifically look at the patient Bill of Rights and to have these conversations with the providers who will be that aspect of your birth team, as Emilie mentioned, because it's important to kind of even have that other person in the room who can ask these questions, so it doesn't seem or it doesn't create a scenario where defensiveness is what you're experiencing from the provider. But I'm going to go ahead and put that in the chat. And then also this recording of today's webinar will be on SisterLove's website, as well as our previous recording on pregnancy criminalization based on the Georgia Life Act, which is Georgia's abortion ban, and self-managed abortion. One thing that we didn't really talk about today, but is another aspect of what Emilie was bringing up, and Noran as well, is that mandated reporting itself under certain circumstances is not required, right? And along with the circumstances brought up by Emilie, it's also not required for self-managing an abortion. But we're seeing a lot of cases here, and we're seeing instances, I will say, in Georgia, or the first, I'm going to say we're seeing the first ever of these cases, at least in 2025 and in this year as well, where folks are being criminalized because of self-managing an abortion or because of prescribed drugs, right? And so with that being said, I want to point you to this website so that you can learn just a little bit more information. And I'm going to go ahead and close this out because I want to be respectful of everybody's time. And so we want to thank all of our panelists and every participant here today for joining us in the third episode of the Know Your Rights, You Deserve Care Without Fear campaign series. You deserve care that honors your dignity, your choices, and your humanity. Together, we're building the tools and the power to make that a reality all across Georgia, especially in rural areas. So we want you all to stay tuned for our maternal health tribunal in the future. In the resources document, you will find a link to be able to connect with the Justice Law and Policy Project, because we will be holding a maternal health tribunal, which is a people's forum to hold the state accountable for all of these stories that were lifted up today of coercion, of discrimination, of racism in maternal health care settings. So thank you so much. And I'm going to let the chat run a little bit because I see a lot of action going on. Yes. Okay. So I'm going to let the chat run a little bit before I close this out fully, but thank you. Thank you. Thank you so much. All right. Bye, everybody.
Bye. Thank you.
Thank you so much.